There's some prison guards in Oklahoma who have just been convicted of torturing prisoners using the song Baby Shark by playing it at high volume while the prisoners were forced into what's called a stress position. I'm Kevin Nooper. I'm an attorney at Nooper and Covey, and I want to explain to y'all today what this, it's a lawsuit and a criminal prosecution that just ended, and the lawsuit is now going to go forward. It was paused during the criminal prosecution, so I want to explain to you what were these officers doing with the Baby Shark song? Why were they using it as a torture device in Oklahoma prison? If you don't know what Baby Shark is, I've been hearing this song a lot recently, so I decided to do this video about it. It is a song that is very popular among toddlers. It used to be a campfire song. It started around when Jaws came out, the movie Jaws. If you're younger, you may not know what that is. It was a huge deal in the 1970s. It's a movie about a shark, and it eats people. And so the movie was like the biggest movie in the world, and these camps, you know, when you go to summer camp, they started making songs about it. The main theme of the Jaws thing was do-do-do-do-do-do. And that morphed over time when the South Korean company sort of had this Baby Shark song about a family of sharks, to now it's do-do-do-do-do-do-do-do after every shark is introduced from the family. So what are these... what happened with these prisoners? What happened with the prosecution? And what's going on in Oklahoma? And why is this song so torturous to people when it's played at loud noises? I actually like the song. I think it's not that bad. It grows on you after you hear it a few times. But these prisoners did not like it, and probably more of that was, you know, the volume and being shoved into this what the stress position is. What is all of this? What you're looking at here is where all of this started, and so I want to start here and show you kind of like what kicked off this media frenzy. For a couple years back, this was a big news story because there was this lawsuit that was filed by the prisoners who were sort of enduring this torture. And obviously, you know, there are some parents who felt like perhaps they're being tortured as well by their toddlers, and listening to this over and over again, if they're some of the ones who don't like the Baby Shark songs. And there are many, many variants of it. So they have baby sharks, you know, that are robot sharks, or they're riding around on dinosaurs, or they're doing whatever. So there's a little bit of variation if you don't like the original one. But you know, it is not that bad. But I think some people, you know, maybe they don't like kid songs, whatever. So this was the civil suit filed, and it's in Oklahoma. You can see there's these 4 people who are filing it. They were all prisoners in this Oklahoma County prison. So there's Oklahoma as the state, and then they also in Oklahoma have a county that's called Oklahoma County. And this sort of says these, you know, the prisoners are filing the complaint. Here's who they are. They're Oklahoma citizens. They're living in this jail. They sue not just the guards, but they're trying to get money, right? So the security guard or the prison guards probably do not have a ton of money. So they also sued the sheriff's office because the sheriff is sort of generally like a county sheriff would be running a county jail and would be, it says here, had responsibility for the management and operation of the jail, which included creating official policies, customs, and practices in place at the jail. And then they also sued the Oklahoma County Criminal Justice Authority, or Jail Trust. So that's a public trust created for the furtherance of purported public functions pursuant to this law. And a trust is just like it's a legal entity where you kind of put stuff in it. This looks like this is like a Oklahoma kind of type of entity that is being created by the government. And then you can see that this says that Oklahoma County had delegated the responsibility of developing policies and procedures to address the administration of the jail to this trust. The trust specifically provides that the Oklahoma County Sheriff was to continue operating the jail until there was like these lease agreements or something. And so apparently there's some period in here where this, to some degree it's operated by the sheriff, and to some degree it's operated by this trust. And then they have this other entity that sort of succeeded it, which means like took over stuff. And then they also have this Board of County Commissioners for Oklahoma County, which is just like a legislature. So they were kind of, it says they're responsible for the jail facility. And then they sue these 2 people who are the actual guards. So Christopher Charles Miles and Gregory Cornell Butler Jr. They have some of this jurisdiction stuff that's just like, basically, I'm suing you in the right court. I'm suing you, you know, this is the right place to do it. And then they start getting into like what happened to these separate prisoners. So this is this first person. I'm not sure how exactly to pronounce his first name. It looks like Jay Lee, and it's Jay Lee Foreman, or Jali. And so Mr. Foreman is 18 years old when he goes to this county jail. It says he's small in stature. It says that so he's a little guy, and it says without any kind of provocation, this Officer Miles sort of comes up to him, accosted Mr. Foreman at his cell door on the 8th floor of the jail. Officer Miles's confrontation of Mr. Foreman was completely unjustified and served no legitimate governmental purpose. Officer Miles's conduct was plainly calculated to agitate, embarrass, and provoke Mr. Foreman. So what does Mr. Foreman say that this prison officer was doing? He says that the Officer Miles yelled at Mr. Foreman the following in rapid succession. And I won't read, they sort of bleep out some of the profanity, so I won't read that. It says, "You blanked up. I'm going to make sure you live in hell. I'm going to blank your mama. I'm going to beat your blank." And then it says Mr. Foreman was afraid for his safety, but he couldn't stop the situation from escalating. It says that this Officer Miles then enters Mr. Foreman's cell, and this Officer Butler is there at the same time. And so Officer Miles shuts the cell door and leaves Mr. Foreman, or rather, Officer Butler shuts the cell door and leaves Mr. Foreman in an enclosed space with Officer Miles. And then this says that this Officer Miles guy keeps insulting and provoking Mr. Foreman. Then he physically turns him around and handcuffs him. And then now both officers are in the jail together, and they pull Foreman out of the cell. Then it says they take Foreman outside the pod, and a pod in a prison is kind of like the area where they have all the cells. Then they say there's this other person. It's another prison guard, Lieutenant Christopher Raymond Hendershot. It says they sort of escort this guy past Mr. Hendershot. He doesn't do anything about it. They place Foreman on a bench outside the pod, handcuff him to a bar behind his back, and then they leave him in that position for over an hour and a half. And they basically said there's no point in doing that. And this is one of these. So you'll see this talked about throughout this lawsuit about stress positions. What are those? Those are a torture method. And what a stress position is if you put people in certain positions, it puts stress on the muscles and on your body tissue. So they're things that don't seem like they wouldn't be that big a deal if you try to do them just for a short period of time. Like if you stood on your tiptoes for a minute or two, there's no problem with that. But if you try to do that for 15 hours, that's gonna, or you're literally forced to do that for 15 hours, that's is not going to be good for you. And there's all kind of positions where if you are just put in those positions and then kept there, they are kind of calculated to cause the collapse of your muscles and to basically just totally stress your body, and it can do damage to you. It's very serious. It's not something anybody should be doing. But they're saying that this was sort of something these officers were routinely doing inside this prison. So this says that they took this Foreman guy, they put him back in his cell, they slam him into the wall, and again, he's a little guy, and then it says this Officer Miles spits in his face. They laugh at him, and then there's no point to any of this. So he escaped the baby shark, but the others, we'll see that coming up with these other prisoners. That these same guards had at some point discovered that was going to be their torture method of choice was baby shark. So the next plaintiff here, the next prisoner, is Daniel Hedrick, and Mr. Hedrick is also an inmate in the jail. It says he's a pretrial detainee. So what is a pretrial detainee? There's something called pretrial detention where you have not been convicted of a trial, but you sit there in jail, because you haven't made your bail or whatever. And sometimes that can be real long periods. That's something that's historically been subject to a lot of abuses, where people who aren't actually guilty are sitting in jail waiting to be tried. It does matter, I think, to some degree, because you're talking about a person who literally has not been adjudged guilty yet by the system. And I guess that doesn't matter to some degree. You shouldn't be sort of torturing anybody in a prison, but it is, I think, from an optics perspective, a little more he's not even guilty yet, right? So, and so you have, it says that Officer Miles and Butler tortured and tormented Mr. Hedrick. What they did is, it says at approximately 3:15 a.m., so in the middle of the night, Officer Butler and Miles took Hedrick from a cell and placed him into an attorney visitation room on the 8th floor of the jail. And what those are is if you're an attorney and you go visit your client who's in jail, they have separate rooms that are designed to allow that visitation. And the thing that is significant to me about that is that one of the things that may be a feature, I don't know for this specific jail, but if you've ever heard of the attorney-client privilege, when you talk to an attorney, even if it's in jail, those communications are private. They cannot be listened in on. They cannot be recorded. They cannot be whatever. So when you take him to that room, it's kind of a flag to me that might have been a room where there's no cameras, right? Or there's no way to see what they were doing in there, which might be why they picked this room. This says Officer Miles had previously removed all the furniture from this attorney visitation room, so that forces Hedrick to stand because he doesn't have anything to sit on. Then it says Butler and Miles then handcuffed Hedrick behind his back and then secured him to the wall, where he was left standing for 1.5 hours. In other words, he was placed in a standing stress position, which is a well-known enhanced interrogation or torture tactic. And this now we get to Baby Shark. This says that after securing him to the wall, the officers played a well-known children's song, Baby Shark, at high volume on the computer adjacent to the room. Baby Shark was played on a continuous loop, and Hedrick was forced to listen to the song over and over while physically restrained in the attorney visitation room. Then this says that the shift commander, Lieutenant Hendershot, who we talked about earlier, was aware that Hedrick had been detained and forced to listen to Baby Shark on a loop, but took no action to intervene and stop the misconduct. And this says this was, the prolonged restraint of Mr. Hedrick was tantamount to torture. It was excessive and had no real basis to do this, right? There's probably no manual that says go lock someone in a room and force them to stand for handcuffed for an hour and a half and crank up the Baby Shark to the max volume so that they are just sitting here having music pounding into their head. And it says that, all three of these guys were subsequently charged criminally, which I'll show you the record of that, sort of what we can see out of that criminal case, which unfortunately does not look like really much happened out of it. I think these guys may be just paying a couple $100 in fines for having done all this stuff, but we'll get to that in a minute. And so it says he suffered a lot of mental in pain and suffering, and certainly I would expect that you would if you're in that scenario. Then we have Joey Mitchell, who is the third inmate at this jail. And again, Mr. Mitchell was a pretrial detainee, so he's not even guilty at this time. And it says, this time it's not the middle of the night, but pretty close. It's 11:45 p.m. This says officers Butler and Miles took Mitchell from a cell and placed him in the same attorney visitation room. So apparently this is some kind of MO of the officers. And it says the officers had, again, removed all the furniture, and then they handcuffed him behind his back. They secure him to the wall, and then they put him in. This time, this guy has to do it for 3 to 4 hours. So he's going to be into like 4 a.m. from midnight to 4 a.m. He's just sitting there, left standing, secured to the wall so he can't sit down or move. And then they repeated it. It says they repeated their inhumane practice of playing the Baby Shark song at high volume. Consistent with their practice, Baby Shark was played on a continuous loop, and Mitchell was forced to listen to the song over and over while physically restrained in the attorney visitation room. The volume of the song was so loud that it was reverberating down the hallways. And then this says that these two officers, Miles and Butler, also threatened Mitchell that he would not be returned to his cell, but be placed in lockdown, aka the hole. So that's where you're off on your own, and you can't. You basically have limited access to any kind of entertainment or anything, and you're just sitting in a cell alone, which is itself some people think is torture, and it certainly is not psychologically good for people to be in solitary for long periods of time. And again, they say this is cruelty, it's torture, it's inflicted all this pain and suffering. Then you have John Basco, who is the fourth plaintiff here. Again, he's a pretrial detainee. Again, he's not guilty when this happens. And this says, this time it's 2 a.m. So apparently these guys, like, they're some kind of night shift officers in the middle of the night. They're just like grabbing people and playing Baby Shark at them. And so it says they took, Miles took Basco from his cell, placed him again in the attorney visitation room. Again, no furniture. Again, forces him to stand. This time it's 2 hours. Again, has the inhumane Baby Shark. Again, it is just insanely loud, so you can hear it all the way down the hall. And again, there is no basis like for doing, according to this. And I think that's probably fair because these guys actually do have a couple of them have criminal convictions now. That this is not something that anybody should be doing. If you're a guard, you don't just get to do whatever you want. And so, if someone does not want to listen to Baby Shark, then they should not have to. And certainly, you should not just be playing it in their ears while they're handcuffed to the wall and can't move and are stuck in this weird position. So now we get to the part of the civil lawsuit where there is kind of like a lengthy indictment of Baby Shark, and the lawyers here just did decide to go on. Maybe they don't like Baby Shark, and I don't know. I'm offended a little. It's kind of fun. It is catchy, but some people, I guess the lawyers don't like it either because they go on kind of their own little rant about this Baby Shark. They say use of the Baby Shark's children's song in a manner described herein is a known device to torment. It's been reported that the city of West Palm Beach has utilized Baby Shark outside an event center to deter homeless people from sleeping or convening in the area at night. More generally, it is well documented that at Abu Ghraib and Guantanamo Bay, which are U.S. military prisons for sort of full accused of terrorism, American interrogators blasted heavy metal music as an enhanced interrogation technique to weaken Iraqi captives' resolve. It says, indeed, the specific Baby Shark torture events at the jail, as summarized above, are now the subject of scientific analysis. So apparently this is like the question of, is Baby Shark torture has been some kind of study? And it literally is. It says in October of 2020, the specific academic question was posed, so what makes Baby Shark so agonizing it's like torture? And I guess that says the scientific answer provided There are actually a lot of reasons for this, clinical psychologist John Mayer, PhD. The music can be hard on the ears, he says. Certain pitches hit the auditory receptors in ways that are physiologically painful. These are high-pitched tones and screechy, elongated sounds like nails across a blackboard. Mayer says these can elicit a painful reaction in the brain, which I don't get that really when I'm listening to it, but okay. It says the lyrics also come into play when you combine nonsensical words, insulting words, and demeaning words with bad music. You have the perfect storm for a horrible song, Mayer says. He says overfamiliarity can make a song annoying too. Beeman adds that someone else. Baby Shark is simple enough to be catchy and has had massive airplay, he says. If you tend to have a strong musical memory for things you find slightly annoying at first, the additional features of Baby Shark can make it especially difficult to take on repeat. I'm not sure what they're talking about when they talk about like demeaning words or insulting words in the song, because it's kind of, it is, I guess, the do maybe is nonsensical, but it's mostly just like Baby Shark do dad shark do. And then they go hunt, let's go hunt, and, you know, safe at last. So there's not really any, like, demeaning, insulting words in here, but, or nails across the blackboard type stuff, but who knows? So there apparently is like a violently, or vehement or extremely strong group of people who just hate Baby Shark. And this has some other, you know, people, I guess, here who don't like this. It says that the utilization of music to harm and torment has been the topic of academic symposiums, and so they start talking about some other types. I do recall when I was a kid, people were complaining the same way about Barney's "I Love You," and people were apparently playing that to make people hate it. It says there's international articles writing about this, saying that Baby Shark was cruel and unusual punishment and puts undue emotional stress on inmates by playing it. It says that, you know, there's a dark history of using children's songs for punishment. Then this talks about Guantanamo Bay playing Enter Sandman, which actually is a good song as well. A really good song, I think. But I could see how, like, even like, let's say you think Enter Sandman's a really good song, but Metallica or whatever, like, you probably do not want one of these songs on loop. And I probably would not want Baby Shark on loop for 3 hours at the max volume while I can't move, for sure. And any song that you're playing for long periods of time is not like at a high volume while you can't move is going to cause serious problems. And that's especially true if it's in the middle of the night, right? Because you're you're at a time when you're supposed to be asleep. You want to be asleep, and someone is just like, which may be why parents have some parents have an issue with it. But you're listening to this over and over, you know, at 4 a.m. So I do see a little similarity for maybe some parents for why they might think this. So I feel your pain if you're one of them, or I don't feel your pain, but I empathize with your pain. And so it says that this. They just, you know, the district attorney, I guess, so because they did, to their credit, I guess, the district attorney went and prosecuted these people, although they did not. It was only misdemeanors. There's some news statements where the district attorney said he couldn't find a felony. I do really kind of wonder about that, because you're like, this really is kind of, you know, even though they're in a jail, that technically, like, you could argue that is kidnapping or unlawful detention, because yes, you are allowed lawfully to keep them in the jail, but not to lock them up in the attorney room with no video and start playing this Baby Shark thing. And, you know, that could arguably be assault to do that. Like, you're exceeding the scope of sort of your legal authority when you're a prison official. So I would have tried a felony, frankly, if I was looking at this or something. There has to be some punishment. And really, like, one of the things I sort of don't like looking at this case is it looks like basically everyone's getting off and there's nothing's going to be done about it. And I'll kind of show you all that in just a minute when I'm done with this. So they're trying to basically sue the county, sue the reason they want to do that. And you see it says longstanding policies and customs. So there are a lot of laws, and we will see that a little bit as well. I'm going to show you some motions about what the county has filed, and they actually got themselves dismissed from the case, although with a chance to try to re-amend what we're looking at here. Based on law that really protects the county from any kind of liability for stuff like this. Even though they're hiring these people, there's no business that could employ people who would lock someone in a room and play Baby Shark at them at the highest volume that you can come up with, and while they're handcuffed to a wall at 3 a.m. and would not have some liability problems. But the government can they've immunized themselves, and they're like, you're tough. That's not my problem. It's your problem. And so that's kind of what the stance that they have taken is. So they start doing, they have some they basically say that there was no supervision at the jail in general. They had a whole management policy of just kind of being hands off and letting guards do whatever they wanted. There's these probable cause affidavits, which are things for the criminal case, but then they've got kind of here. They say that this Officer Miles admitted that he and Butler systematically worked together and used the benches, bars, and attorney booth as a means to discipline inmates and teach them a lesson because they felt that the disciplinary action wasn't working. And it says that so Butler also confirms, hey, I used this attorney booth as a means to, this room or whatever it was, as a means of punishment. And it says that here's part of why the stress position was so bad is that so the part they were like handcuffing them to, it says, was 3 feet from the floor. So it's not like if you're an adult male, it's not at the place where your hands would be. So your hands are cuffed at this 3 foot mark, which means you're kind of forced to, like it says, at this height and with no chair to sit on, it would have been nearly impossible for most inmates to sit or kneel, thus forcing them to stand. So you're standing, but you're kind of like, you're probably going to be standing a little bit down with maybe your feet bent or whatever, and that's part of what makes it a stress position. That's because you can't, your muscles are like trying to hold you in an unnatural position with your arms like stuck that way. So then they have statements from inmates and other staff and say that the Miles and Butler worked together and played children's music on a loop to play repetitively aloud while the inmates were housed in the attorney visitation booth. And the playing of the music was said to be a joke between Miles and Butler. And then this Hendershot guy, who's the supervisor, just like never supervised them, never disciplined them. There were numerous inmate complaints that detailed their history of mistreatment of inmates, ranging from retaliation to mishandling of inmate mail. It says, in addition, nearly 20 handwritten inmate complaints were received at one time regarding one or both officers. And then they were forwarded to the supervisor, and basically nobody did anything about this, even though they were all being told, like, there's this like secret Baby Shark ring in the prison between these two guards who just decided to kind of go do this. And so they kind of go on here and argue that this is like a common thing basically in jails in general, where people just, the people running them and the government doesn't really like safeguard the prisoners the way they're supposed to, which is a big deal, really. No matter who it is, you have a right not to be kind of treated that way in a prison, but that's not what really happens, unfortunately. So they sue them for excessive use of force, which violates the 14th Amendment to the Constitution. They kind of talk about how this is excessive, why there should be liability for the officials and the county, why this is unconstitutional confinement and torture. They say that, Baby Shark constitutes arbitrary and capricious conduct, playing it that loud, and has no rational relationship to any legitimate governmental or penological purpose. Penological is punishment-related purpose. And then they are asking for damages. They want, they don't say the amount. They say in excess of $75,000, which that's just a thing to get it into federal court. There's like a rule that says you can get it into federal court that way, although that may not apply here because everyone's from Oklahoma. I don't know, but that generally is why you see 75,000 is someone's trying to say it's more than that, so I can get into federal court. And they want punitives, they want reasonable attorney's fees. One of the things I don't see here is an injunction, which is usually the kind of thing that you would want here. An injunction is like an order for them to stop doing this stuff to other people. So a lot of times in these types of civil rights cases, the most important thing you can actually win is like an order that sort of reforms conditions at the prison. But for whatever reason, it doesn't look like that's, I'm not seeing that here. But that's the thing that you'd most likely be able to get, and that is maybe most productive for society to sort of order them to follow certain rules or whatever, agree to something that would like fix that. So let's look at what happened to these guys after, because you can see this talks about this criminal prosecution. What happened at first is that this lawsuit got stayed. A stay is a pause. And so there's some motions that are filed, and then the judge decides, look, let's pause this until the criminal thing gets done with, which happens sometimes, not all the time, but sometimes the judges will say, look, the criminal case maybe resolve some of these issues. And it probably, liability wise, these guards probably are the ones who got a criminal conviction. Not all of them did, but I think these two guys are probably like, they're going to get a judgment on them, but they're also probably not going to have any money. So that's the problem. But let's look what they had to pay in the criminal court, which is not a lot. Hey, what you're looking at here is what's called a docket. So I wasn't able to go get the actual, like the court documents. It doesn't look like there's a ton of them. There's maybe one, which probably isn't going to say a lot, but I would have had to like fly to Oklahoma and go to their actual county clerk or whatever to get it. So I decided not to. And this is A docket in a case is, this is what we can see here. A docket is where it's like a list of all the events in the case. So it will say, here's everything, whether civil or criminal, whichever one. Here's all the things that happened. Here's the orders. Here's just a description, sort of chronologically by date, what is happening in the case. And so we can see a little bit here, and this tells us what happened to these actual guards. So you can see the parties are these. It's the state of Oklahoma versus the same three guys we talked about. Hendershot is the supervisor who's alleged to have sort of sat there and not really done anything about it. And then Miles and Butler are the Baby Shark bandits. They are the guys who went in and did this and played the music and like tortured people, essentially. And then you can see it's got sort of events here. So it's showing us like all this stuff. This is like a high level of what happened. And then right here we have the counts. Those are the criminal things they got charged with and what happened. So you can just, there's several of them. It looks like 5 of them. The same kind of thing is happening generally. So they have, you'll note there's different results for Hendershot versus Butler and Miles. So the supervisor, this says his, like, just for this first thing, cruelty to a prisoner. Unfortunately, all these are like misdemeanors. Cruelty to a prisoner apparently is a misdemeanor. The prosecutor said there are no felonies. And so these guys basically got off with slap on the wrist. Hendershot is dismissed at the request of the state. So it looks like the state prosecuted him, but decided that the supervisor really, after they looked at it or something, did not do anything that justified a criminal punishment. But Miles and Butler did what's called a nolo contendere plea. So nolo contendere is like, it means no contest. It's Latin, and lawyers love Latin. And it's, so when you plead no contest to something, it just means I'm not going to say I'm guilty, but I do not contest, like I'm not going to fight this, and I will let you punish me as if I were guilty. People do that just because they don't want to admit to it. Sometimes there's a benefit, sometimes there's not. But it's definitely, if you're able to do that, it's better than pleading guilty sometimes, or you're at least not admitting you did it or whatever. But it also means kind of like in the lawsuit, it's going to be hard to defend that because you have this, like you said, like, yeah, I don't contest that I did this. There's several counts, and you can see when it says deferred, that means it's sort of like they've got a plea deal that defers some punishment if they complete their probation, and they're fine. They've got this sort of cruelty stuff, and then one of these they just dismissed entirely. And you go down here a little bit, and I'll show you. A lot of this is just sort of people showed up, people got arrest warrants, people blah blah blah, just sort of minor stuff that doesn't matter. But if we go to 7, we're going to see one of them, what his plea deal is. So this is something that happened basically about a month ago at the end of March. There's a judge, and the notes in this say the defendant appears in person with their attorney. The state appears with this assistant district attorney. The state dismisses the 5th count that we saw that was dismissed. The defendant enters a blind plea of no contest. It was a blind plea. He doesn't know what his punishment is going to be. The court accepts the defendant's no contest plea over the state's objection. So I guess the state did not want him to be able to plead that. Then after argument, the court rules sentencing is deferred until March 29th, 2025. So he basically gets a 2-year sort of deferred sentence thing. He's going to be supervised by this agency. The defendant shall complete 40 hours of community service and is to no longer work in a law enforcement capacity. The defendant is to pay a $200 judicial assessment fee, $300 fee here, this VCA fee, and court costs. All court costs are due instantly. So the guy has a $500 fine, and he has to not work as any kind of police officer, and he has to do 40 hours of community service. That seems to me to be pretty light. Definitely, he's getting off like at far less sort of impact, I guess, than he imposed on people, given what's being alleged here. And it just strikes me as not a very severe, maybe for a misdemeanor like that. The judge's hands may be tied, honestly, because when it's a misdemeanor count, there are like guidelines, there are limitations. But it is something where it strikes you as a little bit of injustice that someone could go into this position of authority and be kind of a guard at the prison where you are in this trust position, and then you are doing this stuff. It's something that I think should have a more serious sentence. And what did the other guard get? This is for Butler. The other one was Miles. It's the same basic thing: $200 fee plus a $300 fee for $500 deferred sentencing, 40 hours of probation, and you can't be any kind of like police officer or detention officer. So not all that much. And that's what happened in the criminal case. And then what happened in the civil case is they reopened it. And I'll pop back to that one and show you a little bit about the next potential injustice, which is that it kind of sounds like no one's going to do anything about it or pay anything, which includes the county and these sort of entities that don't want to pay anything at all themselves. Okay, I want to walk you through this motion. It's called a motion to dismiss. And this is what happened. Basically, it's from a while back, but it's going to be sort of a live issue again. And there's a court opinion on it. And so is this lawsuit even going to go forward on anyone? Because if you sue these prison guards, those guys are going to have no money and now they can't get jobs as prison guards. So what are they like? They probably have nothing. You can see the plaintiffs here. So this is a joint motion to dismiss and brief in support of, and this is by the Board of County Commissioners and also the sheriff. So the people who actually have money, which is the government who is supposed to be supervising these people, are like, let us out. We shouldn't have to pay. Go after those guys who have no money. And why do they say this? A brief is just like a legal argument to a court, and a motion to dismiss means you're saying dismiss the lawsuit. And joint is that these parties are kind of related, so they're both in the same position, and they're both saying, hey, we should just like, instead of filing two motions, we join in each other's arguments. So what happens here? I'm just scrolling through some of this a little bit to get to the actual sort of legal arguments about what's happened here. So they say, first of all, the board, they have this problem because you shouldn't include both the board and the sheriff's office. Only the sheriff's office is the proper defendant to name. But that for the sheriff's office, the plaintiffs failed to allege facts to support plausible municipal liability claim against the sheriff's office. And municipal just means like sort of a city type entity. It's an entity that runs a local form of government. So why should the court dismiss the board that was supposed to be doing this? Well, because this says that in Oklahoma law, like basically, first of all, they say it's duplicative because under like the law in this area, if you sue one official, it's the same as bringing a suit against the county. Like a sheriff is the same. So they're like this. You basically just done this duplication that you're not allowed to do both. And then it also says, as a matter of law, the sheriffs have the charge and custody of the jail in their county. So the sheriffs are the ones who are actually responsible for training and supervising jail personnel. Therefore, the board's not a proper party because the claims arise out of occurrences that happen in the county jail, and the sheriffs in Oklahoma have the final policymaking authority over the county jail, and they've already been included as a defendant. So basically, they're like, look, board has nothing to do with this. The person who's in charge is the sheriff. So, but then can you sue the sheriff? So they're saying, actually, you're stuck. You can't sue anyone. So they say you seek to hold the sheriff's office liable, but the plaintiff's allegations don't identify any custom, policy, or shortcoming to support a plausible argument that the sheriff's office is responsible for what happened. And the thing to note here is that government has sort of, in general, declared itself immune or less subject to lawsuits. And so you have like sort of higher things you have to prove in order to sue the government or any kind of government entity versus if you can sue a private person. So, and you know, of course, the government is going to do that because it helps them. It says that to establish liability under this Section 1983, Section 1983 is a federal law. If you ever are, you know, like let's say you become a civil rights lawyer one day, you will know that law up and down. It is a law that was created to allow the government to be sued for certain situations where civil rights violations have happened. Because, you know, for a long time, you had this thing called sovereign immunity, which means sovereign is like the one who governs. So a king is a sovereign. You know, the emperor of some place is the sovereign, and the U.S. government is the king of America. They're the sovereign. They rule. Oklahoma County is the king of the county. They rule that county, and so the sovereign immunity is this concept that the one who rules is immune from any kind of suit unless they deign to be sued. If the sovereign says you can sue me, then you can sue me. Section 1983 was an act by the government in response to a bunch of civil rights violations. Y'all all have heard of the history of that in this country, and that's sort of the segregation, the Jim Crow type era. Because of those type of things and the violations that were happening, the government decided to allow itself to be sued over civil rights issues because lawsuits are often a way to correct things like this. When there is a financial penalty to doing it, local governments will tend to be less likely to do it. And so this says that in order under this law, it wasn't just sort of clean, oh, you can sue just like a regular person. You have to show certain things. One of them is the existence of a municipal policy or custom. A policy means you like say, okay, either formally or informally, you're like, you could have a manual that's like, whenever someone does something wrong in this prison, we will baby shark them into oblivion. Or it could be informal. It doesn't have to be a manual. It could be like an informal policy would be all the officers kind of getting together and the supervisors are going, look, you have a problem with that inmate in there. You stick him in the baby shark room and he'll be 3 hours of that. He'll be doing anything you tell him to. So that's like the difference, I guess, informal or formal, but either one of those, that could be like a custom, right? A custom would be them just sort of not ever saying, hey, we're going to do this. But then over time, it just starts becoming the thing because all the guards and they realize, oh, this is great at controlling these prisoners. And so they just start doing it. So you have to show that one of those, and then you also have to show that there's a direct causal link between the policy or custom and the injury alleged. So the prisoners have to have been injured not just by Baby Shark, but by the policy of Baby Shark. The fact that, this policy's existence caused them to be treated according to the policy, and then they were injured because of that. So it can't just be like a one-off. It can't be somebody doing something. It's got to be something that prison system that sheriff has been doing over time and is sort of intentionally doing, not just somebody going rogue. And the sheriff is basically saying these were kind of rogue guards doing whatever they wanted. And I'm not responsible for that. So this says that this is needed to, or that this is intended to distinguish the acts of the municipality, which is the city or the county, from acts of employees of the municipality, and thereby make clear that municipal liability is limited to action for which the municipality is actually responsible. Now, is the sheriff responsible for this or not? On some level, like, it's your jail, and I think on a gut level, I see why they want to limit it, because they don't want sort of unlimited liability that then taxpayers are paying for. But on the other hand, I think the people running it should probably be a little more responsible of like watching what's happening and controlling your guards, because you can't just have people running around doing whatever they want. They say next, it is well established that the government body is not liable under 1983 for the acts of an employee on a respondeat superior theory. And that's kind of this traditional, that's what like a private employer would be subject under these principles of what are called agency law. That means sort of the person who, responds to the superior, I guess, or is, the person who is the agent, the one who controls them is generally responsible, even if you aren't like ordering them to go torture people with Baby Shark. You kind of have the duty to like make sure they're not doing stuff like that. So if this was a business, then it would be very different, result. But so they're saying like, nope, we're the government. We don't have to do that. I don't have to control these people. Or if I do, you can't. If I don't, you can't sue me. They talk about how this sort of policy or custom can manifest itself, they say, which means here's some ways you can prove that some prison had this policy. There could, kind of the ones I was talking about. You could have a formal policy in a manual. You could have just sort of a permanent custom of this Baby Shark stuff. You could have a decision by an employee with final policy making authority. So this might be one way they get around this, is if they can show that this Hendershot guy actually made a decision to like let them do the Baby Shark stuff, and he's the last one who gets this authority, then he's that could get you there. But the sheriff will probably say, look, I'm the sheriff. I'm the one with the authority. Hendershot's just some junior manager. And so nobody, and then ratification means I sort of took an act that approved of the Baby Shark torture policy, which would probably have to be kind of the sheriff. Or the last one that might help them is the deliberately indifferent failure to appropriately hire, train, supervise, or discipline employees. And just reading this last one is kind of like maybe the strongest. Deliberate indifference means just like you literally just don't care what those guys are doing. You did not do anything really, or pay attention or talk to your hiring, your training, your supervising, or your disciplining. And if you are getting, I think a lot of times these sheriffs are sort of ignoring complaints from prisoners when they'll just like, oh, the prisoners are the prisoners, they're criminals, they just say stuff. But then that also, when you treat it like that, you lead to situations where the guards could be doing, this frankly is not, there are many, many worse things than this happen in prison. I do think this is very bad. It sounds like, oh, it's funny, it's Baby Shark, but it's actually kind of bad as a form of torture to stick someone in that position. And that's really not an overhyped word to call it torture. And getting a bunch of reports of that is something you probably should investigate, or like put cameras in there or start watching them. Like, I don't, on some level, know why all our prisons don't have cameras watching what all the employees and the prisoners are doing all the time. But, that's just how we are sometimes. So they say basically you didn't show a custom. You didn't show that this is we don't have our manual. There's no, they say it's basically like there's no facts about like why you say this would be a custom. You just say it happened. You don't say that this is like something that we actually made as a policy to do this as a punishment. They say that you don't. Then they put a lot of focus on this one that I was talking about, this last element, inside some law saying, sort of trying to get them out of this. Like, you don't explain these failures. Was there another incident that put us on notice? Was the training inadequate? How was the training related to this? And then they cite a Supreme Court case that says that a municipality's culpability for deprivation of rights is at its most tenuous where a claim turns on a failure to train. It means it's like the weakest claims compared to the other ones are the failure to train ones. And the reason is that they can only exist where the failure to train amounts to deliberate indifference. So they're basically saying it's a high standard. Like, it can't just be like, oh, I messed up the training. It's got to be like, I knew about this deficiency in training and didn't care. And then they say you also have to show a pattern of these violations by untrained employees. And it has to be kind of like highly predictable, patently obvious, that a single officer's training problem is not enough to support this. Got to be program wide. It can't. These are just all kind of cases from. There are actually other jurisdictions. Some of these, the Ninth Circuit and Fifth Circuit, are not binding in this court, but they are sort of respected-ish. I mean, I guess like they're higher up federal courts that whose decisions are going to be given more weight, even if they don't sort of bind this court. They're in the 10th Circuit right here. And they cite a Colorado court that said that one prior incident is insufficient to give them notice. Although it does sound like these guys have been doing this sort of a while and have been getting lots of complaints. And then they're starting more law, basically saying you don't meet kind of the requirements of showing that we should get sued as this county. It has to be frequent, and there's just a few of these guys. Now, some of this really may just be that they don't have proof of it. I mean, the honest sort of thing is like, did it really happen like this? This may actually have been something they were doing all the time, but how many prisoners are willing to come up and say that? There's also a special problem with these prison cases, which is that anybody still in the prison may be reluctant to talk because if they're still doing stuff like this, or if you have guards who do stuff like this, then the prisoners sometimes may not want to put their name on a lawsuit because they may be like, what are they going to do to me if I go help sue these people or help sue the government? And then they start talking about this Justice Department report that they say is like a buzzword. And it basically looks like the U.S. Department of Justice had gone and described Oklahoma County Jail as being kind of like a horrible place with all kind of terrible conditions. And they're like, oh, it's been, 15 years. We're better. Finding that our jails were horrible in 2008 doesn't mean anything. Why are you talking about what our jails used to be like? Although, on the other hand, if you're still in 2020, 2 or whatever, or 2020, like literally torturing people with children's songs, it does tend to suggest that perhaps there have not been that many reforms since 2008. So what did the judge do about this? I'm going to jump to the opinion just so y'all can see. There's some more briefing on it, but this will show us like what happened. It's not final because the judge is going to let them try to amend, but it did dismiss these claims, at least with one chance to sort of come back and see if they could revive them by changing the allegations that will be in the complaint. And we haven't seen whether they'll do that or not yet. Okay, so here is what the court ordered on the motion to dismiss. And so this will tell us at least the court's thinking. It is from back in 2022 before the case got paused, but we can kind of see what the court thought about this and why it did this dismissal. And it's sort of a dismissal if we scroll to the end. It's without prejudice. Okay, you can see that. So, and this says if at a later stage of the case, right, let's start here. Proceedings in this case have been stayed for the time being, so it's on pause. If at a later stage of this case, plaintiffs perceive that they have in hand facts sufficient to satisfy the applicable standards as discussed above, they are free to move to amend. What does that mean? So this means that this judge here, it's a U.S. District Judge, he's decided, look, without prejudice means your legal claims are not gone. I'm dismissing them because it looks like at least the thing we saw at the beginning of that complaint, it's not enough if that's what you're saying and that's all you're saying. Without more facts, you can't win. But if you get more facts, through this criminal case that's going on or whatever, I'm going to let you come back and sort of amend the complaint, which means you can go change stuff. You can go put in, what did you learn from the criminal case? What have you learned since then? You have more that would help you get over this hurdle. And so you can come back and try again. It's not really like an indicator like if he had said with prejudice, that would mean it's gone. There's no legal way you can win. You're done. So he gives some factual background. A lot of this is what we are seeing earlier. So it says they were forced to listen to this well-known children's song, Baby Shark, at high volume on a loop. They talk about, Miles was driving a knee into Foreman's back, was slamming him against the wall of the cell, was spitting in his face, and kind of all this stuff that we looked at. And then he starts quoting the law, and some of this is the law that we were looking at in that motion earlier. So it says he's addressing this issue about, can this board be in there or not? He says the plaintiff said they sued both defendants out of caution, abundance of caution, and that there's a disagreement between federal courts and Oklahoma state courts with respect to, like, can the board be liable or not? And the court says, look, I conclude that board should be dismissed, but without prejudice. So you can add later. He says those claims are duplicative between the sheriff and the board. The sheriff is the appropriate official to name because the sheriff's responsible for training and supervision of jail personnel and has the final policy-making authority for the jail. So consequently, I dismiss it without prejudice. It sounds more like he probably will not let that one be revived, because he's not really saying, like, here's what you're missing here. But it may be sort of just caution on the judge's part, saying, like, look, if something sometimes they do that, they'll dismiss without prejudice, because there's like a policy or maybe a kind of preference to allow plaintiffs to try to amend their complaints to make, if there's something they can allege. You don't want a plaintiff, like, losing just because they forgot to put some fact in there or they didn't realize there was a legal issue or whatever. The judges will give you a second chance and sometimes a third or fourth chance if there's a reason to do that, to see, like, okay, can you fix this? Is there something I'm missing as a judge? Whatever. They're trying to get it right. And so they oftentimes will say, okay, I'll let you try again. Then this says that the sheriff, so he's like, okay, board, you're gone. Sheriff also seeks dismissal, even though they are the one responsible for what happens in this jail. And he says the 10th Circuit, which is the circuit that he's in, so this district judge has to follow all the decisions of this 10th Circuit. If the 10th Circuit says something or the Supreme Court says something, then this district judge, no matter what he thinks, he has to do what they say. And there's been a lot of cases where some of these lower judges have been frustrated by things that, I'm not saying he is here or whatever, but especially in the police context, I'll say there have been a lot of judges who have expressed frustration over some of the rules that they are being forced to follow, but they have to follow them. That's just what the law makes them. So this says the 10th Circuit sort of makes clear, or has held, the 10th Circuit, this is a quote from the 10th Circuit. The Supreme Court has made clear that a local government may not be sued under Section 1983 for an injury inflicted solely by its employees or agents. Again, that's what we saw earlier, that you can't use these employee theories that you would in a private business context. A government as an entity may only be held liable when an execution of a government's policy or custom, whether made by its lawmakers or by those whose edicts or acts may fairly be said to represent official policy, inflicts the injury. So unless it's like the guy in charge, the sheriff, is doing this or has sort of, made this the policy, you can't do it. So this is the same stuff that we were looking at that was quoted in the brief earlier. So, and then again, some of this is the same. So he's saying, like, look, this is the background, and now I'm going to decide these facts based on this background. The plaintiffs appear to have relied on two forms of municipal policy: an informal custom and a failure to adequately train and supervise. And he says, so he starts with the failure to train, which is kind of the one that I was saying earlier is kind of the bigger one. And now he's citing these 10th Circuit cases. And one interesting thing, if you, I talk about citation in some of our some of the videos. I just made one about how these citations work. If you're like a wannabe lawyer or a paralegal or something, and you have interest in that, this APPX means that a case is unpublished. You can see he's saying unpublished, but cited as persuasive. So when I talked about the 10th Circuit being binding on the lower court, there are two types of opinions. There are published opinions or unpublished opinions. When you see this APPX, it's federal appendix. You know that it is an opinion that was not published. When an opinion is published by a higher court, like an appellate court, it is binding. It is something that they're saying, we've put the time into it to, like, we want you to follow this opinion. Sometimes, and I worked on one of these appellate courts, and kind of the process, I worked on the 5th Circuit. So I was working for a judge who's on the 5th Circuit. And they will have panels of 3 judges. They call it a panel. So all 3 judges are looking at a case, and they'll write out these long opinions. But a lot of your cases, I'd actually say a majority of your cases that you have coming up to you are ones that are kind of real simple, or it's just like real clear that the appeal should be denied usually. And so in a lot of those cases, you may decide not to publish the opinion. You may have a short opinion that either the clerk wrote, or they have a whole office of people who are sort of permanent attorneys there who will write opinions. The unpublished opinions are the ones that have not really been as sort of polished, I guess. The judges are not looking at them as closely, and the reason that they make them unpublished is because if they mess something up and have an error in there, like, all three judges have maybe not scrutinized them as closely as they should, or if they're published, you don't want something slipping through in like casual language or something that all the lower courts like latch onto, and they're like, oh, well, they said this, but it's really just some like, the judges have not really sort of thought about it as much or whatever. And so they will make them unpublished. So that means it's persuasive to the lower judges, but they can, the district court here can just be like, that one's wrong, I'm not listening to it. And he's allowed to do that. If it's unpublished, then he only has to be like, okay, does this opinion from the court that's above me persuade me or not? And if that opinion does not persuade me, then I'll just ignore the 10th Circuit. And he's allowed to, and that's sort of, that's for good reason. So this one, it looks like he was persuaded by this opinion. So this sometimes you just like the language in them or something or whatever. Like, and then it says, only where a municipality's failure to train or supervise employees evidences a deliberate indifference can the failure to train or supervise be considered this policy or custom. That's what we looked at earlier. And it says it requires proof that they disregarded a known or obvious consequence of an action by the municipal actor, which is the sheriff here. Says that you have to show like actual or constructive notice. Actual notice is like someone comes to the sheriff and says, hey, they're playing Baby Shark at the prisoners at 3 a.m. in that jail and forcing them into this position, this torture position. Constructive notice would be like you don't actually know, but you have so much stuff that like you really should have known about this rather. Like, I don't know. It'd be like if the sheriff like walks into the torture room and he sees Baby Shark, videos being played over and over, and he sees like, a Baby Shark like restraint device or something, and he's like, why is all this stuff in here? He might wonder what's going on, or he should have known what's going on, essentially. And so the judge says that the plaintiffs have not alleged sufficient facts to plausibly support an inference that the defendant sheriff acted with deliberate indifference. So because they don't show a pattern of similar incidents. As the plaintiffs have alleged based on the state's probable cause affidavits, which are those things from those sworn statements from the criminal case, that at least 6 additional detainees were physically victimized. However, the affidavits do not specifically indicate when the 6 additional incidents occurred. It says, basically reading these affidavits that were in the criminal case, these incidents appear to have occurred after plaintiff Hedrick was injured. So basically one of these guys that is suing, yes, more stuff kept happening after he was injured, but that doesn't show that there was a policy when he was injured. So he says that, and the judge quotes this law, incidents that occur after the incidents at issue cannot provide notice to a municipality of a deficiency in its training or supervision, which kind of makes logical sense, right? Like if you're saying the sheriff did the sheriff know about this, like a pattern or not, the first guy being injured is not part of the pattern. Just so if you're stuck with these rules about this that the government has set for sovereign immunity, then that one does kind of make sense a little bit. He says for these other 2 plaintiffs who were injured in late November and December or late November and early December 2019, in the court's view, that doesn't constitute a pattern of tortious conduct. That is not torture. That is tortious, which means conduct that can be sued upon. That's not based in some kind of contract. Like you injured someone, it's tortious. In addition, though the affidavits state that the additional inmates were physically victimized, there's no indication as to how. And so there's no indication they were physically victimized in the same manner, i.e. like were these other 6 people Baby Sharked. It says that these 20 handwritten complaints were received at one time, but the affidavits don't state when the inmate complaints were received. And the history of mistreatment was kind of this wide range of stuff. Like some of it was retaliation. Some of it was like more minor stuff like mishandling inmate mail, which is not as serious. So the judge is basically saying, look, this is not like, you're not showing that all of the conduct was the same kind of pattern. Some of this stuff is Baby Shark torture. Some of it is like messing with someone's mail. That doesn't show like a pattern of the Baby Shark torture. Then he talks about this 2008 report, but the court says, like, I can't infer that this report will put him on notice because it's not talking about the same type of like Baby Shark stuff. Um, and and then the court's saying like, look, deliberate indifference is a high standard. There's only a narrow range of circumstances that can justify it. We just don't have enough evidence here from what you said earlier. Then he talks about this informal custom, and it's kind of the same thing. Like, look, you just haven't alleged enough facts, whether they're true or not, in your complaint to let me know that there is this pattern of stuff. So the judge has said, at least for now, unless they can find more stuff, and that's the opinions from, you can see July 2022. So a lot could have come out in the last year or so. But the plaintiffs have not filed for like the case has just gotten unpaused as I'm doing this video, so we don't know what they're going to file here. So, what is the sort of takeaway of all this that we've been looking at? I mean, this really kind of like bad or scary or disappointing. Really, part of all this is you're looking at it going, it kind of looks like nothing's going to happen from this, right? Like the guards are just going to walk off and pay a $500 fine, and they won't be guards again. And the sheriff's just going to be like, whatever, it's not my problem and not my fault, and so I'm not paying anything. And, you know, maybe they stop doing stuff like this, but, you know, our country has a real problem with kind of how our prisons are run. If you ever watch the show 60 Days In, you will see a lot of stuff like this in prison. Some sheriffs who have gone on that show have actually, to their credit, have known that they have a problem in their jails because the sheriff's elected, right? So they could come into this situation not having been the guy who actually caused it. So you could, you know, if you're elected sheriff and you go look at this jail, you might be like, what in the world is going on in this thing that I am now in charge of? But this stuff is really pervasive throughout our country. Not necessarily Baby Shark torture. It's kind of a hook, you know. It is a little funny, but it's also not funny. And so, like, I hope it causes people to like pay attention to this, or you know, maybe watch this and see what can go wrong. But this incident and what we're seeing in this video is really kind of like a microcosm of why it all goes wrong. Nobody is held responsible. There is not really the legal ways that you could hold someone responsible are really not very effective. And you can see why they all just sort of collapsed. And so you've got these judges going, I can't do anything. And the criminal judge going, well, I can't do anything. And the prosecutor going, well, I can't do anything. And the sheriff going, it's not my fault and not my problem. And, you know, there are reforms we could make, but they have to come from the government. And the government sort of is worried like, oh, I'll get sued into oblivion. They could probably allow themselves to be sued for some limited amount. So don't let yourself get sued for $20 million, but give something. And, you know, without financial penalties, people don't change their behavior. Without some kind of penalty or punishment or whatever, nothing changes. And so this unfortunately is something that's pretty common in prisons, guards mistreating inmates. They do still have human rights, even if they are people in jail for having done things or whatever. And, you know, it is disappointing is maybe the way to put it. So hopefully, I don't know. I hope someone can figure out something to do something about it. If I were making suggestions to what to change, it would be make it easier to sue and make there more consequences. Maybe they need a felony law for guards who do stuff like this, because it literally is a felony. Like, I know they have a uniform on, they're wearing the hats, but that does not make them like all powerful, and it does not, it should not mean that you don't have consequences for what you're doing because you're wearing a little hat with a star on it. But that's kind of what's happened here, and so maybe there should be felony prosecutions of people who do this. If you don't want to hold the government liable and you don't want them to have to pay taxes, pay money on it, then maybe you need a jail for people who do things they're not supposed to. Maybe you need cameras in the jail so that you can go back and look, because we could see everything that happened, and these plaintiffs could go see how often was this happening. If there were cameras all over that jail, then you would know, and you would be able to protect people a little bit more. So I don't know. If you want to watch more videos like this, I do a lot of celebrity lawsuits. They're not always as sort of dark in ending as this one is, but you can go click. There will be some end card screens as that, and you can come subscribe if you want to see more in-depth legal analysis of different issues in the news like this.